and chairman of the Human Rights Commission of Sri Lanka. So we have, as I said, a very eminent panel. We have a bit of a time crunch, and my apologies for that. For a conversation this important, one would have wanted more time, but such is life and scheduling imperatives. So I guess the first question, the first person who I'll ask to speak is Irfan Qadir Saab. And because when we talked about, and this has been part of our public conversation, when we talk about conflicting judicial decisions, the inconsistency in outcomes, which for sort of, for a view of law, which in my view is perhaps not accurate, but it is that, essentially you apply the law to a set of facts and then the rest is scientific and predictable. So in the Pakistani context, the challenges that we've had with this, and particularly in a federal context, particularly in a context with in the polarized space that we operate in. So I asked Irfan Qadir Saab to start and speak. And
Bismillah ar-Rahman ar-Rahim. My fellow guests and ladies and gentlemen, today's topic, eroding the rule of law, conflicting judicial decisions. This topic has been a great concern for me most of the time, because for the last so many years I have been dealing with this kind of conflicting judgments, and today I got the opportunity to speak on these conflicting judgments. The topic itself suggests that there have been conflicting decisions on similar issues. The legitimacy of the judiciary was undermined by such conflicting decisions, and the judges were rewriting the law and the constitution. The judges were creating their own law so as to legitimize their illegitimate decisions. The mess created by these conflicting judgments was an absolute embarrassment for the entire system, especially the judges who got themselves entangled in such exercise. I have not used the word judiciary because we should not undermine the judiciary as a whole for the conduct of only few judges who rendered these conflicting decisions. But through these judicial decisions, they did brought the legal order of the country in a very difficult situation. Everything went topsy-turvy and situation became very chaotic as far as the legal order was concerned. Most of these judgments had one common feature in them, and they were based on endless hair-splitting and were unusually lengthy, containing hundreds of pages, and all this was being done to give such judgments some semblance of reasoning and legitimacy. Otherwise, these judgments were outrightly unconstitutional and could not be justified by any stretch of imagination or extensivity. This is a very sad state of affairs as far as Pakistan's judicial system is concerned. However, the generality of decisions in cases coming before the judiciary in the hierarchy of courts do not suffer from this malaise of conflicting decisions. Unfortunately, the delays in court system undermine justice, since justice delayed is also justice denied. Although, as regards the generality of decisions, conflicting decisions are not to that great an extent to which they are in the matters where there are political repercussions. So the role of as I was saying this, the conflicting decisions have mostly occurred in the realm of those matters which have political repercussions. I would thus confine myself to these decisions only and would not touch upon other areas of such conflict. Although the overall performance of our judiciary has been far from perfect. The role of judiciary in shaping Pakistan's legal order, because if we need to comprehend that what chaos has been brought by these conflicting decisions, we must also understand the role of judiciary in Pakistan's constitutional history's perspective and the role of judiciary in shaping Pakistan's legal order during times of regime change has been a consistent feature throughout its constitutional history, spanning over 7 decades. From the landmark Maulvi Tamizuddin's case to the judgment of 31st of July 2009, the judiciary has played a pivotal role in safeguarding the interests of new regime, often invoking the doctrine of necessity to legitimize its actions. These judgments have primarily aimed at protecting the new regime as well as the Chief Justice and his judges. The invocation of the law of necessity has become somewhat of a ritual in these circumstances, serving to validate the actions taken by the judiciary in support of the ruling authorities. One notable departure from this trend is the case of Mian Nawaz Sharif. This happened in the 90s, where ousted Prime Minister was restored to power. Now, this was one decision where judiciary went outside the ambit of looking after the interests of the ruling elite of that time. And here we see that judiciary rendered a decision wherein the Prime Minister was restored, but the impact of this decision proved to be short-lived, as both the Prime Minister and the President eventually had to resign from their positions. Otherwise, in all the decisions of this kind, with regard to change of government, with regard to overthrowing the government, with regard to new governmental order, we find that judiciary always stored the line of those who were to come in power or who were in power. And this was one decision which many people consider was independent, but how much independent it was, obviously there are lots of ifs and buts in that decision too, because there also judiciary was guided by certain extraneous considerations, and it was again not a purely legal decision having regard to the jurisprudence in this realm developed till that time. Despite the significant role played by the judiciary in these matters, it has often come under scrutiny and criticism. The judiciary has been held accountable for its decisions, with questions raised about its impartiality and adherence to legal principles. In essence, the judiciary's involvement in shaping Pakistan's legal order during regime changes reflects the complex interplay between law, politics, and governance in the country. While its actions have at times been contentious, they underscore the judiciary's crucial role as a guardian of the constitution and rule of law. I must here very candidly express myself that as far as judicial role of judiciary calling themselves to be the guardians of the constitution or the rule of law, thereby giving an impression as if judiciary is the sole guardian of rule of law and the constitution is not correct at all, because the role of the executive is also very important in being the custodian of rule of law and being the guardian of the constitution. And Parliament, to the greater degree, is the mother of all laws. They are also there to guard the constitution and the rule of law. So judiciary, as some judges claim, with some feelings of megalomania, that they are the sole guardians of rule of law and constitution in Pakistan, to the exclusion of every other organ of the state. This perception, the law wanted to empower more judges, or rather the Supreme Court, to constitute benches, but the like-minded judges thought that this was against the independence of judiciary. How could anything be against the independence of judiciary, which empowers more judges rather than one Chief Justice? Because Supreme Court consists not only of Chief Justice, it consists of Chief Justice and other judges. I mean, these were blatant violations of law, which do not require very lengthy reasoning, which do not require lots of references from law books, which on the face of it was illegal. And this was most unfortunate. And then we come to a very recent for others to follow, and especially if Supreme Court has given inconsistent decisions, the impact is always felt by the High Court and by the lawyers, and it becomes a very difficult area for the High Courts to take a decision in a matter where there are conflicting judgments. Now, these conflicting judgments are many, but as due to paucity of time, I will be referring to some of them. Had to remark, which have had lot of impact as far as Pakistan's legal order is concerned. Very recently, the Supreme Court took upon itself the task of announcing or determining the date of elections, notwithstanding that this is the domain of the Election Commission of Pakistan. In this regard, Supreme Court went on to render almost 2-3 decisions, one after the other. In one decision, they said that it is the governor of a province who is to announce the date of elections. In another, it was said, no, it is the President of Pakistan who will announce the date of elections. Yet, in another decision, they announced the date of elections themselves. And lastly, in the last decision, Supreme Court held that this is not our jurisdiction. And since all the parties here have agreed and they have arrived at a consensus that the elections are now to take place in February of 2024, so let the elections be held in 2024. So this is a total chaotic situation that we have an election commission mandated with the responsibility of holding free and fair elections. But the matter is to be decided by judges through multiple decisions, and even within their own decisions, they are all inconsistent decisions, conflicting decisions. And in a similar situation earlier, certain like-minded, the word like-minded judges is a new term to our jurisprudence. And this term, like-minded judges, developed when our last Chief Justice, I would not name him because I want that now that he has retired, he should relax. We don't want to burden him unnecessarily, and I wish him well. But since we are here talking with regard to the jurisprudence that was developed, so our friend, the former Chief Justice, what he did was that he, with impunity, constituted benches of his choice. When those judges were known to all and sundry like-minded judges. After all, why do we have like-minded judges? Why can't we tolerate difference of opinion? Why can't we resolve our differences? Or why can't we have 2-3 opinions and let it be decided by the majority? There can be 2 reasons for this. Either the person forming the benches has an authoritarian mind, or he has some conscience which is perhaps whimsical, or there may be something more to it which I may not dilate further. But it is extremely unfortunate that we pass through a very sad period in Pakistan's history where the Chief Justice solely had hijacked the entire court and subjugated the Supreme Court, even the brother judges had to remark in their orders that this is not the way that benches should be constituted. Rather, benches should be constituted with a consensus of senior judges, and eventually a law had to be brought in, and that was the Practice and Procedure Act of 2023. And we see that in this process, Pakistan's largest province, the Punjab, the government of Punjab was overthrown by the like-minded judges by rewriting the constitution, in which they held that the election that was held of the Chief Minister of Punjab, the votes of those who defected will not be counted, whereas Constitution doesn't say so. Constitution only says that anybody who defects will lose his seat, but nowhere it says that votes will not be counted. In any case, the Punjab government this way was overthrown. So this was the second instance. First one was about the date of election. Second is that the Punjab government was overthrown by such decision, which was not only conflicting with Supreme Court's own decisions, but it was in direct conflict with the Constitution of Pakistan. And during these proceedings, judges were afforded a chance to dispel such notions that these matters should be referred to a full court, for which there was a nationwide demand, but this demand was brushed aside by the great like-minded judges, by means of a highly defective reasoning unknown to jurisprudence of any age or any period. Now, likewise, when a new law came in that like-minded judges' benches should not be formed, this law was legislated, and that was the Practice and Procedure Act. Supreme Court, through like-minded judges, the then Chief Justice, suspended the Practice and Procedure Act, and while he remained Chief Justice, that law remained in limbo, but it became operative after he was gone, and later on the Supreme Court upheld the Practice and Procedure Act. It is not a very complicated matter at all. All that the law said was that instead of one Chief Justice constituting benches of his choice, the law wanted to empower more judges, or rather the Supreme Court, to constitute benches. But the like-minded judges thought that this was against the independence of judiciary. How could anything be against the independence of judiciary, which empowers more judges rather than one Chief Justice? Because Supreme Court consists not only of Chief Justice, it consists of Chief Justice and other judges. I mean, these were blatant violations of law, which do not require very lengthy reasoning, which do not require lots of references from law books, which on the face of it was illegal, and this was most unfortunate. And then we come to a very recent case, which is probably still going on, and that was the controversial decision of like-minded judges in the matter of trials of civilians by the military. Now, Constitution nowhere says that civilians can't be tried by the judiciary. In fact, there is an article in the Constitution which says that all the military laws are exempt from the operation of fundamental rights. But to declare all this unconstitutional, the like-minded judges took several months, hundreds of hearings. Anything which is declared unconstitutional can be seen maximum maybe in one hearing, two hearings, three hearings, four hearings, not in scores of hearings, that an effort is made to declare a law to be unconstitutional, because the basic principle of declaring a law unconstitutional is that as far as possible, an effort will be made to reconcile the Constitution with the law which is sought to be declared unconstitutional, instead of making such an effort. In fact, there was no need for such an effort. On the contrary, effort was being made for several months that how to declare it unconstitutional, and it was declared unconstitutional, and now the matter is in appeal, and there's a different view now, and Supreme Court has suspended the order passed by the like-minded judges. And these are some of the few cases of conflicting decisions. Now, if I go further, there are many more. In Pakistan, I won't be able to talk on each and every decision because there are many. But some of the very basic decisions that I think I must share with you. The one such decision was judgment of 31st of July 2009. That is unique in world's legal history, that where a Chief Justice gets restored and he constitutes a bench of his own choice, picking up 13 judges later appointed afterwards, and 14 judges of Supreme Court oust 15 judges of the Supreme Court. And those 15 judges, most of them were constitutional judges. And these 14 judges, they were all PCO judges. They had taken oath under the PCO of General Musharraf. And still, they had the cheek to oust the constitutional judges and declare the constitutional judges to be PCO judges, which was absolutely against facts. But this happened in Pakistan. It was like a broad daylight robbery. I was also one of the judges who was thrown out then. But I don't hold that against them because I don't think I was affected by that. But Pakistan's jurisprudence was affected. That entire judiciary was uprooted by the restored Chief Justice and his group of judges, and 14 judges ousting around 70 judges of Pakistan's judiciary. And in that decision, those judges were not a party to the proceedings. They were never heard. And since all of you belong to this legal fraternity, most of you, all of you know it so well that a decision which is rendered without hearing somebody or against a person who is not a party, all over the world, such decisions are called void ab initio decisions. And I today strongly feel that that was a void ab initio decision. In that decision, the subsequent restoration of Chief Justice was declared legal and constitutional, which in fact was neither by means of any law nor by the Constitution, but that restoration of Chief Justice was the result of executive order made by the Prime Minister at the floor of the House. There was no backing of law or the Constitution, and all those subsequent appointments were illegal. But in any case, much time has gone, and I am not saying that now, after so much time, we should revisit that in such a manner that we should now turn the system of justice, whatever is left, in a completely chaotic state. So I'm not saying that, but I'm just highlighting that what kind of decisions were rendered. And as far as this judgment of 31st July is concerned, it was a decision in conflict with Zafar Ali Shah's case. In Zafar Ali Shah's case, some of these judges themselves held that whenever there is intervention by the armed forces, and that intervention is for the welfare of the people, because now the law of necessity was changed, and the reasoning in Zafar Ali Shah case was based on principle of salus populi suprema lex, that welfare of the people is supreme law. In other words, this judgment of 31st of July was not only a departure to Zafar Ali Shah's case, but this judgment of 31st of July was total antithesis, and it was Zafar Ali Shah case also, and this judgment also. They were, I would say, Zafar Ali Shah case especially was again an old wine in new bottle, wherein Maulvi Tamizuddin's case, the then Federal Court or Supreme Court, they held that they based their decision on law of necessity. Here, law of necessity was changed into salus populi suprema lex, which was just old wine in new bottle, nothing new. And so this decision of 31st of July is the basis of legitimacy of the present judiciary. which is most unfortunate. And lately they have been revisiting some of their judgments. And I would say that this judgment also would be revisited in the coming days so that the Supreme Court make its slate clean. Another very important case in these matters was the NRO case, National Reconciliation Ordinance of 2007. And this was a law which was declared unconstitutional by a Supreme Court at a time when the law had already expired, but it was resuscitated through fiction. A law which came to an end by the fiction of Supreme Court, it was resuscitated, saying that it will continue for another 1 year till the Supreme Court completes its hearing and then declares it's unconstitutional. Otherwise, that matter had become infructuous. There are many other cases of this kind. We have the 18th Amendment case. We have another case of the Prosecutor General of National Accountability, absolutely illegal decision. Then we have judgment of 54 bureaucrats who were posted around 2010-11, and their appointments were declared illegal. They weren't even a party to these proceedings. Then the court started appointing their own chairman of the National Accountability Bureau. 2 chairmen were ousted by the court, one after the other. And all these unfortunate decisions have led to a very chaotic jurisprudence in Pakistan. And very recently, we have 2 cases, very interesting. One is the Nasla Tower case, and the other is the Constitution Avenue 1 case. In Nasla Tower case, it was decided that since the construction was on the land which was not legally owned at that time, or where there were certain violation of laws taking place, so they did not have any regard for a bona fide purchaser without notice who had purchased those apartments. But the ego of the Chief Justice, whatever the yardstick was then, all that was declared illegal, and Nasla Tower was pulled down. Whereas in the matter of Constitution Avenue 1, almost on similar facts, it was not pulled down. Rather, they said that it needs to be regularized, and that building was regularized. Now, these are 2 conflicting decisions which will continue to haunt some of our judges, especially those judges who were also a part of Nasla Tower case and also a part of the Constitution Avenue 1 case. Then the most important cases in this ambit are firstly the lifetime disqualification of Prime Minister of Pakistan, Mian Nawaz Sharif, and then a totally opposite decision in the opposite direction, and that was the reversal of lifetime disqualification by the Supreme Court of Pakistan. So on one hand, Supreme Court disqualified a Prime Minister, overthrew a sitting government, the entire cabinet was sent packing home. On the other hand, after several years, the Supreme Court came to the conclusion that this lifetime disqualification is not countenanced by the Constitution, and that has also happened very recently. And not only that while disqualifying the then Prime Minister Nawaz Sharif, they went on even to hold that he should be tried by NAB for his unexplained assets, and he was tried by NAB by constitution of a JIT. And what was the result? The result was the Prime Minister was convicted, but eventually he was acquitted. Therefore, the entire exercise was illegal or uncalled for. So there's a complete silence as regards to that now, what is to be done now. And apart from that, another very important case which preceded this Mian Nawaz Sharif's overthrow, another government was overthrown in the year 2012. The then Prime Minister Yusuf Raza Gilani was held guilty of contempt of court. Yusuf Raza Gilani was held guilty of contempt of court and resultantly was disqualified. He was disqualified, but now he's the chairman of the Senate, and that decision was absolutely incorrect. So, having given you some crux and gist of these decisions in Pakistan's judicial history, especially by the Supreme Court. I think I would not go on further with all this because today I have so many cases in my mind that if I start continuing on this, it might take another hour. So I don't want to take your time because there are other speakers also. So now I would just get to the point straight, and that is that what is the solution after so much havoc and mess has been created by these conflicting decisions? In my humble estimation, I would say that there's an immediate need for a constitutional package, and that constitutional package must ensure that strict trichotomy of powers should be preserved and the supremacy of the parliament should be preserved, and obviously parliament is the mother of all laws. Then we must ensure zero interference in the matters of executive and other organs of the state. Likewise, other organs should also not interfere in the matters of judiciary, and we must empower the Supreme Court in a manner in which no Chief Justice or no group of judges can subjugate the entire Supreme Court. And lastly, we need to strengthen the Election Commission of Pakistan, that whenever the elections are underway or are being held, Supreme Court stays its hands off, that there should be no interference from courts in the matters of Election Commission. These are some of the very basic things that they are to be done as immediately in the next few months on priority basis. Yes, this is my wishful thinking, but this can also happen. Thank you very much for a very patient hearing. Thank you.